Hello, everyone. Welcome to yet another podcast of the Law School Policy Review. I'm an editor, Shaurvi Chaudhary, and I have alongside me Devang Pandey, who's a shadow editor of the Law School Policy Review. Today, we are joined by Professor Dam. Uh, our guest for today, Professor Shubhankar Dam, is a distinguished constitutional scholar and public expert whose work significantly reflects the contemporary debates on judicial institutions and constitutional governance in India. He currently serves as the chair of public law and governance and associate head global at the University of Portsmouth and holds the prestigious B.R. Ambedkar Chair at the Columbia University in New York. These also reflect the themes for today's podcast, which is concerned largely with the design and functioning of constitutional institutions, with a particular focus on the judiciary. Our podcast today is titled Benches, Benefits, and Beyond, examining how life after the bench shapes judicial behavior, independence, and public trust. Professor Dam will share his insight on the ethical question that arise after a judge leaves the bench. This discussion will include the politics of judicial retirement, its impact on the constitutional framework of judicial independence, as well as the impression it leaves on the public and the media about the integrity of the judiciary. For this, we will also delve into contemporary questions and notions about this constitutional institution. I'll now allow Devang to start asking questions.
Hello, Professor.
Hi, Devang.
Uh, so, of course, we had the pleasure of engaging with the scholarship while preparing for this podcast. And while studying this post-retirement phase of judges and the employment which they're offered, the work suggests that the concerns around it are not just about individual misconduct, but they are more of a systemic phenomenon based on incentives. And similar concerns were raised in the Constituent Assembly, where some members warned that governments might be able to tempt judges with post-retirement positions. So my question is more of a two-parter. First, that how can such incentives affect the perceived legitimacy of the courts? And secondly, regarding many reforms which have been suggested to address this. So in your view, what approach could meaningfully strengthen judicial independence while also allowing the system to benefit from the expertise of a retired judge?
Thank you, Shaurvi and Devang, for having me. It's wonderful to interact with you. All right, so your question has at least three parts. Let me outline a response by first explaining what I see as different types of judicial corruption. This argument about post-retirement jobs is often made in the language of corruption. But there are at least two types of judicial corruption, and it's important for us to be able to distinguish these things to make sense of the question you posed. First, some corruption is what you might call personal corruption. This is the most obvious version of corruption. Imagine a judge who takes a bribe, delivers a particular judgment. This is the most standard form. For a variety of reasons, this kind of corruption is also quite invisible, at least at the appellate level, meaning the high courts, Supreme Courts, at that level. But separate from personal corruption is a type of corruption that you might call institutional corruption. And here the focus is not on any individual decision, any individual transaction arising from the decision, but the focus is on a set of incentives that create what you might call a type of misalignment that enables miscarriage of justice. Now, post-retirement jobs are one such incentive, but there are many other incentives that operate within India's judicial system. The important thing to understand is that these incentives typically act as an influence in the background. And judicial behavior doesn't have to be intentional. In fact, it is entirely possible that the impact of these incentives are often unintentional. They are psychologically, it is quite likely the judges themselves are unaware of it. And these incentives may exert an influence without judges realizing that there is an influence being exerted. So as I explained in one of my articles, imagine a case that requires an interpretation of a statutory provision. Now imagine there are 5 possibilities, 5 ways in which you can interpret that provision. 2 of these interpretations are closer to the view the government prefers. One of them is more or less neutral. And then there are 2 other views that are anti-government, that are opposed to the sort of interpretation the government might prefer. What I've argued is that post-retirement jobs act as an influence that consciously or otherwise makes judges more amenable to the type of interpretation, the kind of interpretation that is more pro-government. As I said, they may be doing this intentionally, they may be doing this unintentionally. But it's that influence that you can discern over a period of time, over a set of cases. And that's what I have called institutional corruption. It is not about any particular judge. It is not about any particular bench. It's not about any particular decision. It is a general incentive that has the capacity to misalign, or let me put it this way, that's the capacity to influence how judges go about conducting their judicial role. So your question was about the perceived legitimacy of the court in the face of such incentives. If you have a system where an incentive is constantly present, and there is at least a possibility, I'm putting it in the mildest form possible, there is at least a possibility that these incentives are interfering with judges' capacity to decide freely and fairly. You ought not to be surprised that the public will question whether these decisions, at least the ones that sections of the public don't like or don't approve of, if these are the product of extraneous reasons, extraneous influences, which in the Indian case, at least at the appellate level, has to do with post-retirement jobs. But I should point out that post-retirement jobs are only one kind of incentives. If you've read Prashant Reddy and Chitrakshi Jain's amazing book on trial courts in India, you will see that they make the argument that increasingly trial court judges are hesitant to offer bail to under trials because it seems to impact both their capacity to remain in the job and to not be hit with charges of corruption. So Reddy and Jain show in their book that judges who have given bail, who have been willing to give bail to under trials, are more likely to either be removed from office or to be investigated for a whole range of charges, including corruption. And it's not surprising that today in India, the Supreme Court is repeatedly having to remind trial court judges that you can give bail, that it is in your power. You should not be pushing these matters to the High Court and eventually to the Supreme Court. But you can see from Reddy and Jain's book, there is a reason why trial court judges are so hesitant to give bail. It is not an accident. The system has designed a set of incentives that make it difficult for trial court judges to give bail. Now, the second part of your question had to do with reforms. Specifically, you asked me what approach could one meaningfully take to strengthen judicial independence while allowing the system to benefit from the expertise of retired judges. I disagree with the premise of this question. If you look at the question, if you look at the manner in which this question is framed, it suggests that there is something specific, something unique, something valuable about retired judges that we ought to be benefiting from, that there is something special or distinct about this category of people. I disagree. I think India has done itself an enormous disfavor by creating a system where we seem to attribute all sorts of wonderful values, honest, impartial, independent, all of these wonderful adjectives that you can think of. We attribute these to one class of people, namely High Court, Supreme Court judges, and somehow expect them to uphold these values in a way that no other person in India can, no other category of people can. I have to say, I completely disagree with this framing. I think this is a huge disfavor. We are doing a disfavor to the system ourselves. We should not elevate judges to a class that is in some sense beyond us. Judges are not superhuman beings. They are part of Indian society. They reflect all of the good and ill of Indian society. They do not come from a different galaxy. And to somehow expect that judges are in some sense special, unique, or radically different from the general population, I think is a disservice. And I'll explain to you why I say it's a disservice. Today in India, there are I cannot think of any controversy, any large-scale event. I can't think of a controversy where the solution isn't to immediately appoint a judge-led commission to investigate, identify facts. What happened? Who said what? Why did this happen? What went wrong? And I repeatedly ask myself, how did we get to this point where we seem to think that the only people capable of investigating a matter, assessing basic facts, providing some thoughtful reflections, the only people who are apparently able to do this are either sitting or retired judges. I think this is harmful for India. We seem to attribute mistrust. We seem to attribute all sorts of negative, problematic values to everyone, politicians, elected or otherwise, bureaucrats, lawyers, academics. So apparently everybody in India is compromised, except judges. I don't think this is good for for any democracy. Surely we should not be trying to create and maintain a system where the only people who seem to be the repositories of these wonderful values are people who are outside of the democratic system, people who are outside of the electoral system. So you ask me, how can we continue to, how can we maintain judicial independence while continuing to benefit from the expertise of retired judges? My response to you, in a very long, convoluted way, is to say we should stop our obsession with retired judges. We should stop thinking about how to benefit from the expertise of retired judges. Instead, we should be asking, how do we create a system that incentivizes elected members of parliament to at least occasionally behave in non-partisan ways? We should be asking, how can lawyers, how can academics, how can bureaucrats, how can we design a system where a whole range of people can demonstrate these positive values that we now associate only with judges in India?
Professor, just to follow up to that, I feel my follow-up is a two-part question. Firstly, then who do you believe should be leading these commissions to lead the investigations? Should it be lawyers? Should it be parliamentarians? Who should be the police officers? Who should be the one leading these? That's the first part. And the second is, another issue that comes up with this is that judges who do not who want to work beyond the retirement age do not have any other avenue barring arbitration. A lot of judges do get into arbitration. But other than that, what can they realistically do after their retirement age, which is 65 in the Supreme Court, 62 in the High Court? I read that there was a Venkat Chalya report in 2002 that kind of suggested increasing the retirement age, and the 114th Amendment Bill, which now got passed in 2010, was also to kind of rise the retirement age of judges to 65, particularly for the lower courts, where I believe the age is 61 to 62, but I don't remember. And I remember reading that other countries as well has a high retirement age. Do you feel that increasing the retirement age is a solution, or what are the avenues then do they realistically have to get into post their retirement?
Thank you, sure. Again, these are very valid questions. So the question as to who should lead commissions. So look, there are two kinds of commissions. One are these statutory tribunals, in the National Green Tribunal and Company Law, the Law Tribunal and all of those. And then there are these commissions of inquiries, which are set up occasionally when sort of controversies arise, sporadic controversies arise. So far as commissions are concerned, it's, at least from sitting in the UK and observing the functioning of a whole range of tribunals here, it's not clear to me again, it's not at all clear to me why we have somehow, we have nationally come to the conclusion that the independence of these commissions depend on the presence of retired judges. And I find this logic, this approach, even more baffling. Because if the argument is that retired judges pandered to governments to get these post-retirement jobs in the first place, how is it that suddenly once they become the chairperson of a tribunal, the president of a tribunal, somehow they magically regain their independence? I don't understand the logic. So again, to get back to your question, if not retired judges, who? I don't have a simple answer to that question. All I can tell you is that even the UK has, a large network of tribunals. They are not manned by retired judges. These are judges that the system appoints, the bureaucracy appoints, and they seem to be able to do perfectly fine. The manner in which we appoint judges to trial courts and district courts in India, either through some years of experience or exams or a mix of both. Why can't simply India's tribunals have a network of judges who are recruited in that manner? Why does it have to be retired judges or sitting judges is not at all clear to me. So that's the first part. So you asked me who should be in these systems. Now your second question had to do with appointment age. I think there is a strong argument for increasing the age of retirement. That is sensible. How far it should go is not clear to me. Clearly, there were proposals made to increase it to 68. I think some commissions may have even mentioned 70. But here is what I can tell you. No matter how much you increase the age of retirement, ultimately judges do have to retire. There is no getting around this. And the real question is whether the system pays enough, whether India's retirement packages are large enough to be able to sustain a reasonably respectful, comfortable retirement. Bear in mind that some of the desire to be involved in these tribunals, these commissions, isn't pay always. Sometimes the desire comes from the need to be part of the system, so to speak. I mean, put yourself in the position of a High Court or a Supreme Court judge, having held a very public post where your presence really matters. Day in and day out, you're making decisions that impact life in its broadest sense. To then suddenly transition to a life where you're practically invisible and immaterial, psychologically surely is not easy. So sometimes I have no doubt judges pursue these things. They desire these things not because the financial incentives are important, but simply because they're almost conditioned to be part of a system where they matter. And that I don't think there is a simple solution for that. Like I said before, we have created over the last 50, 60 years, we have intentionally created a system where we have endowed retired judges, including sitting judges, a whole host of attributes. And it's not surprising that over time, they have started believing this story. So I think reform can only begin with other players in the system believing that they too can behave in non-partisan ways. They don't always have to make themselves beholden to some interest or the other. Unless we can do that, I don't think there is a simple bureaucratic solution that you can design, some sort of rules you can write to remove this incentive this influence from the system. I don't think this is just about identifying some creative set of rules and policies. I think it requires regenerating a sense of belief amongst a whole host of characters and their capacity to behave in impartial ways. Other systems clearly do it. If you observe India's legal system and the sort of debates that we have, we take it for granted in India that these are necessary debates, that these afflictions are somehow integral to the legal system, but they're not. They're not. Here in the UK, in the last 5 years, I can give you examples, at least 3 examples, where the police charged a sitting prime minister with a misdemeanor, where the police charged a sitting first minister, roughly the equivalent of Indian chief ministers, with a crime. I can give you an example where the police charged the spouse of a sitting first minister with a crime. It is possible. Clearly, systems exist where the police function without, being beholden to current office holders. And if the police can do it in the UK, the police in India should be able to do it too.
So, firstly, thank you for your much enlightening answer. You raised a point about trial court judges not being able to go ahead with bail as easily. And I believe I remember former CGI Chandrachud mentioning the same one.
Yes.
In a public speaking event. So it is a recognized problem for sure. And I believe my second question has been answered to extent through the first response, but I would still like to go there because you argue about a system of economic influence in your piece about the politics of judicial requirements in India. This economy of influence where systemic incentives shape judicial behavior. And this idea resonated with me through broader debates about judicial appointments as well. For instance, in India, we have had this debate over NJAC versus the collegium. And the collegium is often perceived as something which favors a certain class. Professor, am I audible?
I can hear you, yes.
Oh, okay. So, do you think that judicial appointments in India might also reflect this economy of influence? And is this different from the economy of ignorance, which you also have posited in the different pieces?
Thank you. This is an insightful question. Look, clearly something interesting is happening with how the collegium functions in India and the type of recommendations they are making. But I am not entirely convinced that this is something drastically new. I'll be the first person to admit, perhaps I'm wrong, but in the last, say, 5 odd years, perhaps a bit longer, I'm increasingly seeing analysis reports that suggest that the collegium is operating under an influence. The collegium is making recommendations that favor the government. The collegium is trying to satisfy the government's preferences through its recommendations. Now, I'm sure some of it, there is some influence. I don't think there is any doubt about it. To me, the real question is that influence new or different in some sense? Is something special happening in the last, say, 5-7 years? Something that's different from what has gone on, say, roughly since 1999, when the five-judge collegium was set up. And in that context, I'm not sure the collegium is doing anything particularly new. Like I said, there may be an element of newness. I think we are talking about degrees here rather than type. So let me put it this way. This is a rather crude way of putting it, but I suppose for the purpose of this conversation, this will suffice. It is possible that there are two big worldviews out there regarding the Indian Constitution. Yeah? So one, you might say, very crudely, very roughly, the Congress worldview of the Constitution, and then there is the BJP worldview of the Constitution. Like I said, these are very simplistic binaries. The world is far more complicated than this, but let's just work with this for the purposes of our conversation. If you accept the premise that there is something like a Congress worldview of the Constitution and a BJP worldview of the Constitution, is the collegium's functioning over the last 5-7 years any different from what it has been doing for the last 25 years? I'm not sure it is any different, and here is why. If you have had a system where those present in the system, I mean judges in the collegium, were already predisposed towards the Congress worldview of the Constitution, then there was no need for them to do anything extra, do anything additional in recommending judges, in engaging with governments through their recommendations. Because the operating system was the Congress worldview of the Constitution. Those present in the system, I mean judges who were part of the collegium, they shared that worldview, and they recommended judges that shared that worldview. And you had 10 years of Congress rule, or UP rule. So the room for clashes, from what I can see, was minimal. But because of the electoral change that we've had in the last 10 years, there is clearly a difference of opinion about the type of person who should be elevated to the Supreme Court. And it's surely not a surprise that the government wants more people, presumably the government wants more people who share what you might very crudely call the BJP worldview of the Constitution. So the clashes that you are seeing, or what is now being framed as the collegium giving into government demands, the collegium trying to appease the government, it's not clear to me that all of this so-called appeasing, so-called giving into, is any different from what went on for the previous 15 years, so roughly between 2000 and 2015. The reason we never noticed, or perhaps the reason many people didn't want to notice is because the collegium, government, and the recommendations that were coming in, they all were, broadly speaking, part of one umbrella. So there was no real room. There was no need for any clash, so to speak. But because those judges are still in the system, they are making recommendations now, or they have been in the system at least over the last 5 years, and they were the ones making recommendations. There has been a tussle between the collegium and my hunch is that as newer judges come into the Supreme Court and the profile of the average judge in the Supreme Court changes, what we now, or what some people now regard as clashes between the collegium and the government, will likely disappear over time. Because increasingly you will have a different type of judge that will recommend the same judges of that same kind. So the need for a clash, I think, will disappear over time. So this is a very convoluted way of saying, I'm trying not to be crude about this. This is a very convoluted way of saying that influence has always been a feature of collegium recommendations. I do not think the collegium has ever functioned without the government's invisible hand of influence. The reason we are noticing it more now, in my view, is that there is a difference of worldviews between the collegium and the government. And like I said, as more judges come into the Supreme Court under the existing collegiums, over time, this clash will disappear because you will have a collegium that shares the BJP worldview of the Constitution. If you continue to have the BJP in power, then in some sense, you will replicate what India has had roughly between 2000 and 2015, roughly those 15 years. So I don't know if this made sense to you. I'm trying to put this in a way that is not very, very crude. I'm sure I failed in that regard.
Thank you for the previous session, Professor. There was obviously a network issue, and we'll be resuming today. My question to you is, Professor, that courts often say that public confidence is central to judicial authority. At the same time, democratic institutions must remain open for the people. Where should the line be drawn between legitimate criticism and alleged defamation of the judiciary? How must this be viewed in the light of the ban of the NCERT textbook referring to institutional corruption in the judiciary?
That's a difficult question. The NCERT textbook crisis is not surprising to me. If you look at the last 20 years, the sort of criticism the Supreme Court has received, it seems the only people who are apparently able to talk about corruption in the Supreme Court or the judiciary in general are retired judges, retired Supreme Court judges. There are all sorts of examples of retired judges talking about corruption in the Supreme Court. And that seems to be the only acceptable discussion. Anyone else who has had the audacity to talk about corruption has faced severe consequences. I can give you several examples. Transparency International did some sort of a report in Jammu and Kashmir, and that institution was hauled up for contempt. So I'm not surprised by how the court has behaved with regards to the NCERT textbook controversy. But I think a lot of the responsibility for this rests on the shoulders of scholars, journalists, even politicians, who for the last roughly 3 decades, so roughly between 1990 and 2010, 2015, so about 25 years, encouraged, applauded almost everything that went on in the Supreme Court in the name of judicial activism. I suspect part of the reason they were so happy to applaud these decisions, even if they lacked any sort of doctrinal basis, if they lacked, if the court demonstrated a willingness to ignore procedural constraints, was simply because the court was producing verdicts that a lot of people liked. The decision in the NCERT case reflects that sort of lawlessness. It's just that now the script has flipped. So the court's order, that the order to bar these authors from engaging with any sort of textbooks in India, engaging with research that's based on government funding, that part of the order is so obviously unlawful and lacks any basis in statute or precedent. But I'm not surprised the court has produced this sort of a verdict. As I said, I think it's the direct result of the lawlessness that has gone on. You might call a kind of doctrinal lawlessness that has gone on for the last roughly 25 years. And I think those who are now beginning to criticize the court have a lot to answer for. Bear in mind that there were voices, and it wasn't as if everybody was encouraged by the sort of things the Supreme Court in particular was doing in the 1990s, in the aughts, even the early 2010s. But I certainly remember those times. Anyone who had the audacity to question the court's approach, to point out that doctrines matter, rules of statutory interpretation matter, procedures matter, and we should not ignore all of these things just to get the sort of verdicts that appeal to us. Anyone who had the audacity to point out these very elementary things typically was dismissed as a conservative or someone who didn't care about people's suffering. I think all of those people now have a lot to account for, because the lawlessness in the NCERT case is the latest example of that. The kind of doctrinal lawlessness that you see in these, increasingly in these decisions, is rooted in that culture that grew up that became part of our judicial consciousness in the 1990s. So I think a strong element of public legitimacy that you began with rests in our ability to ensure that decisions have some degree of consistency, that courts take doctrines into account, they take rules of interpretation into account, they take procedures into account, that we don't ignore these things simply because the outcome is inconvenient. When we become an outcome-driven process, an outcome-driven court, you ought not to be surprised that you then have large sections of the people who think that law really boils down to judges' whims and fancies, that there is really nothing else to it. So I think if you want to maintain legitimacy, the court should be taking their own decisions, precedents and doctrines seriously, rules of interpretation seriously. Unless we do that, I think we are stuck in this cycle of lawlessness.
Yes, so thank you for that. So moving on to the next question. In Active After Sunset, the politics of judicial retirements in India, your famous piece, you alluded to the dormancy of Article 128 in the 21st century. Is this just a matter of fact, or is there any underlying reason for this?
So, dormancy, this is not a 21st century phenomenon. This is not the only time the court repeatedly appointed retired judges to the bench to assist with workload was in the 1950s. So in the first decade, I'm inclined to say most, I may be wrong about that, but certainly many judges in the 1950s who retired from the Supreme Court came back for varying durations. Some came back for a year, some came back for even longer than 2 years. But I think by the time we get to the mid-60s, that practically disappeared from the court. Sitting judges no longer seem to appoint retired judges either in the high courts or in the Supreme Court. Now, part of that is quite easy to understand, given that now there is a large group of people, a large group of high court judges and Supreme Court lawyers who are competent to be appointed to the Supreme Court. It is not a surprise that retired judges are no longer appointed to the Supreme Court. I should point out, though, very recently, the Allahabad High Court, I think, passed an order, an administrative order. I think this was a decision of the collegium at the High Court level, where they recommended the names of a few retired judges to have their tenure extended, or more precisely, to be reappointed for a certain duration. I am not entirely sure if the government has accepted that recommendation.
Just to follow up on that, Professor, do you think that this action by the Allahabad High Court kind of ties into the point we were making the last time we were talking about increasing the retirement ages? Is there an argument we can use here to kind of further that point, or not really? Am I reading too much into it?
You see, the structure of incentives that we talked about previously could potentially apply even to these retirements. After all, Allahabad High Court in the last 2 or 3 years would have seen a number of retirements. And the question is, why did the Chief Justice or the collegium at the High Court level, why did they pick these 3 judges? Why not other judges? So it's difficult for me to see that you can get out of this cycle of incentives simply by reappointing judges who have retired. There is clearly an argument to be made that at least the retirement age of high court judges needs to be increased, simply because 62, by any definition, is a relatively young age for people to retire. And given the fact that in India, pensions are, by standards of legal practice, by standards of law practice, fairly modest, I think the argument to extend the retirement age is very strong. But as I said previously, no matter where you draw the line, you still have to have a retirement age. And ultimately, there is no easy solution to this question of incentives. What people do as they come closer to retirement, or what judges do once they retire, is a question that won't disappear anytime soon.
Okay, Professor. Thank you for that. Our last question for this. Professor Pranav Verma's work shows that essential religious practice doctrine has effectively placed courts in the position of determining what counts as essential to religion with judges interpreting scriptures and religious practices themselves. At the same time, he has pointed out concerns about post-retirement appointments and the institutional incentives that may shape judicial behavior in politically sensitive cases, particularly post-2014. Do these concerns strengthen the case for reconsidering the essential practices doctrine themselves? As a matter of constitutional law, should courts continue to determine the questions of theological essentiality? If no, then how may the court decide the level of intrusions and reform within religion permissible under Part 3 of the Indian Constitution?
Thank you, Shoravir. That's a very good question, and I don't have a simple answer. I'll say two things about the question you posed. So first, consider the argument about post-retirement jobs. I have read Pranav's article. It's a very good article. I must admit, I'm not convinced about the argument concerning retirement jobs and the essential test. In general, I'm very skeptical of claims that try to connect specific decisions to post-retirement outcomes. Any judge, whether a High Court judge or a Supreme Court judge, over their term in office, would have decided a large number of matters. It's hard for me to see how one gets to the conclusion that judges were given jobs because of these specific decisions. And the counterfactuals are quite easy to see. It's even in these matters, the essential tests that you're talking about, even in cases involving essential tests, there would have been multiple judges on these benches. Some would have gotten jobs, perhaps some didn't get jobs. So the claim that somehow judges did these things, they came to these conclusions because they wanted jobs, and the government rewarded them with jobs because they delivered these particular judgments, that's a claim that I struggle with. I think there are too many counterfactuals to conclude that claim is in some sense robust. In any case, that's my view. Now, so far as the essential test is concerned, the essential features test, look, whether we like the current version of the essential features test or not, I don't see how we can ever get to a point where essential features or something like that, some version of essential features is not needed. I don't see a system where we can simply get rid of the very idea of essential features to decide what counts as what's protected under religion. Any person who comes to the court and raises an Article 25 claim will require must be able to show, let me put it this way, any person who comes to the court with an Article 25 claim will require a response from the state. People can come to the court with all sorts of bizarre claims in the name of religion. Unless you take a view that the moment someone raises an Article 25 claim, the moment someone utters the word, this is my religion and therefore protected, no matter how outlandish, no matter how bizarre the claim is, unless you take that view, an essential features test is inevitable. Ultimately, judges will have to decide whether claims made by individuals or organizations can reasonably be said to fall within the scope of any religion. Let me give you an example. This is something that I thought about for at least 20 years now. Imagine someone comes to the court and says, I belong to the Church of the Gay Lord. And the church, and a central tenet of this religion, of this church, is that gay people should be able to marry. Therefore, when the state prevents gay people from marrying, you are infringing on my freedom of religion. How would you respond? If you don't believe in an essential features test, then how would you respond to a claim like that? So my view is, perhaps the manner in which the court has gone about implementing the essential features test is problematic. Perhaps it's biased towards one religion, or perhaps some sects within one religion. Maybe it ought to have a greater degree of understanding of what religions require, especially what minority religions require. But I do not see a system where you can get rid of the essential features test, because as I said, if you get rid of it, you will be stuck with a position where anyone who comes to the court and asserts an Article 25 claim will succeed, because there is no other way to assess whether the claim someone is making is valid or not. Okay?
Thank you for that, Professor. I feel that this was a very enriching discussion for both Devang and myself, and I'm definitely sure that our audience would enjoy watching such a discussion themselves.